This webinar is presented by HCSA, the Hospital Doctors Union. HCSA is the only trade union and professional association dedicated exclusively to hospital doctors, wherever you are in your career. HCSA has advised and supported doctors who have been considering raising patient safety concerns or who have faced detriment for doing so. Our recently published guide, Speaking Up on Safety, is a primer on the sorts of actions which may be deployed against you when you do raise concerns. If you're not yet a member of the HCSA, you can join us at hcsa.com/join. The link will be in the chat. Before we start, there's some quick housekeeping. Please be aware that the presentation sections of this webinar are being recorded and will be publicly available to view at a later date. If you have any questions, please use the Q&A function on your screen. We'll come to these later in the session. Please be aware that if we come to your question, you will be able to unmute and put it to the panel directly. If you would prefer to remain anonymous, you have the option of doing so in the Q&A box, in which case we will ask your question on your behalf. You can also upvote those questions you'd most like to see answered by clicking on the up arrowhead. So the webinar this evening is going to be presented by me. I am a doctor. I was a consultant neurosurgeon for many years before I left my post. And this first part of the webinar is going to be focusing on my case. Then Martin Bond, one of our national officers in the Northwest, is going to discuss possible options and things that you can do to sort of mitigate your circumstances and so on. We're keeping it very focused to hospital doctor situations and the sort of initial part of what goes on. Please do believe what I'm going to be telling you about my case. It is hard to believe that it is actually true and that what actually goes on goes on. If it hadn't happened to me, I wouldn't have believed it myself. But I'm really excited to actually be able to discuss what happened to me and to share the knowledge and to hopefully get people to understand what actually goes on. And then hopefully we can perhaps make some small steps towards changing the culture which results in these sort of situations. I don't have many slides when I present. I usually like to really connect with the audience, which is tricky when I can't see anyone, but hopefully I can get my message across. Our main aim is to highlight this issue, bring the conversation to the fore, on the table, if you will, such that we will be able to change the toxic culture that has led to so much destruction. I would like to set the scene by highlighting some resources that I have found extremely useful and would have been game changers had I been more educated about people behavior, bullying, and so on at the time that I was under attack. Must reads are The Chimp Paradox for People Behavior, Peter Duffy's Whistle in the Wind, and David Drew's Little Stories of Life and Death. Both tell their stories in great detail, and for me were very useful because they taught me that nothing has changed when it comes to the treatment of doctors over the past 10 to 15 years when it comes to whistleblowing. My disciplinary hearing and David Drew's were identical. Michael Swin's book, Hitting Your Head Against a Brick Wall, recently released, is interesting not because of the details of the issue that he raised, but because he tells the story from the other side. He talks about what management wanted him to do in order for them to be able to discipline Michael Swin's colleague, confirming what we have worked out as the doctors being disciplined. The TED Talk, Fixable, by Amy Cuddy, How to Spot a Bully in the Workplace, Parts 1 and 2, is superb. My advice is you absolutely have to listen to it, even if you think you work in a safe, well-functioning environment. Amy Cuddy is an American social psychologist who gives an excellent description of a bully, their tactics, and how to deal with them. It is brilliant. I have included her talk because I know that there are doctors who raise patient safety concerns and those concerns are acted upon. These doctors are probably part of the hospital mafia and may be bullies themselves. However, if you're not part of the chosen few and are bullied, then I suspect that if you raise patient safety concerns, you are much more likely to pay for doing so. Initially, I worked happily in the unit I was in. However, after about 2 to 3 years, 2 senior colleagues left, and the bully, who had previously not been able to gain traction, was allowed to recruit secondary bullies whose signal boosted his message. The pH in the department changed, and the beginning of the end began. I raised concerns about a very prestigious service in my trust that I was part of. In fact, I was part of the team that got the service commissioned. I did it in good faith because I was genuinely concerned about the decisions that were being made in that service. However, this made me very unpopular. I noticed that previously, if I made a comment in a meeting, it was taken seriously. Now I was being ignored. Staff who'd been friends became distant from me. I was becoming isolated. At the same time, I could see blatant recruitment of secondary bullies from other specialties in the open plan office of 64 that we occupied. The lead of the service that I was concerned about was an ally of the bully, and further secondary bullies were being recruited in the service, which was cross-site. I suspect that my practice was being scrutinized behind my back, and when no fault was found, I think that a clinical situation was created by the bully that went badly wrong, even from the bully's perspective. This incident will be referred to as the index case. It took me 4 years to realize why my colleague had done what he had done. It was unbelievable. But there is no other explanation. If you think something is really odd and suspicious, it may well be. Believe your gut instinct, even if you don't really want to. There was an RCA and a Royal College notes review into the index case, and an independent expert wrote a report. No one was found to blame, but there was learning regarding communication, amongst other things. One of the doctors involved, he who wrote the incident form that triggered the RCA, had been involved in a clinical incident with a tragic end at the start of the year, and his behaviour had been recognised as similar in the index case. However, it was ignored by the RCA investigation team in both cases. The medical director involved in the index case was involved in the first case, so probably understood the link and therefore realised that the rather damning incident report that said doctor wrote may have been done to protect himself. The medical director made sensible decisions regarding the case, but my bullying colleagues were furious that I had not been disciplined. The medical director retired, and one of the secondary bullies became interim medical director. The new medical director was appointed, recruited from overseas, and had never been a medical director before, as I understand it. I was summoned to see the medical director about 6 months after she started in post. She had been briefed by the interim medical director and another colleague. I can only imagine that this was the bully. It was clear when we had the meeting, where I was ably supported by the HCSA, that I had been described to her as a completely different person to the person who sat in front of her. However, unbeknownst to me, she had already been persuaded to set the ball in motion regarding reopening the index case. She was very much a puppet of the mafia and was supported in the meeting by the head of HR, who also assisted the hearing manager in the disciplinary hearing that was to come. That head of HR was a key player in my case. The medical director stated that another expert report into the index case was going to be sought. Reasons unclear. The new report was damning with regard to my involvement in the index case, and that case, along with several other allegations, which were malicious, were used to trigger an MHPS. The report was heavily flawed, but despite instruction to the trust from the PPA that I should be allowed to comment on the report, my comments were never sought. This is now over 2 years from the index case. The case was classified as conduct by the trust, being the easiest way to dismiss a doctor, but the allegations were clearly under capability and conduct, in which case it should have been dealt with as capability as per the MHPS guidance, which would have more likely resulted in retraining as opposed to dismissal. The MHPS investigation was conducted. The case investigator was a junior consultant surgeon who'd never carried out an MHPS investigation before. She was assisted in part by Capstick's employee and latterly by HR. It became apparent that there were two letters, that had not been disclosed to me, and the trust refused to do so on request. The MPS then brought a High Court case to try and obtain the letters, but the judgment was that the trust had no legal obligation to show the letters to me in the realm of an MHPS. We appealed but lost, although the judgment was better in that it stated that outside of the MHPS, we may be successful in obtaining the letters. That turned out not to be the case. The investigation was eventually concluded almost 2.5 years after it started. Delays were in part due to the High Court trial and COVID. This was 4.5 years after the index event. The trust failed to investigate a protected disclosure I made during my interview. The case manager's outcome letter stated that there was a case to answer regarding the index clinical case and one other case. I was able to review all the transcripts of the interviews the case investigator had completed, and interviewees had clearly misremembered events. By this stage, the new medical director from overseas had left and gone back home, perhaps because her job was done. The new medical director, the third medical director involved in my case, was in fact from the same department as the hearing manager at the disciplinary hearing, and was employed at the trust at the time that the overseas MD was appointed. So why wasn't he appointed as medical director at that time? You have to wonder whether the overseas medical director was employed purely as an axeman. At the disciplinary hearing, the panel was made up of the hearing manager, who was a part-time surgeon, who was the sole decision maker, HR support, the previously mentioned head of HR, and an expert witness from another hospital. The trust was represented by a KC rather than a case manager, which would have been the norm, so big money was being thrown at the case. I was represented by my trade union official. Fundamentally, my case was about the trust covering up the fact that there had been 2 deaths in the trust and 1 doctor, not me, linked to both deaths. I was the scapegoat. I had an idea of this at the time, but only became fully aware of the situation with the first death at a later date. Without going into too much detail, the hearing manager was highly likely to be biased, given his knowledge of some of the witnesses appearing for the trust. One in particular was closely linked to the cover-up, and the patient that died in the first case was in fact a patient of the hearing manager. The new medical director was a witness and was also in the same department as the hearing manager. This conflict of interest should have been admitted but wasn't, and other relationships were denied, downplayed, when the hearing manager was challenged. In a disciplinary hearing, the side that calls the witness questions the witness first, then there is a cross-examination by the other side, unlike in an employment tribunal where there is only cross-examination. Witnesses clearly misremembered events when being questioned. One witness made up elaborate untruths during their cross-examination. When my trade union official was asking questions that got close to the bone, he was shut down by the HR manager and the hearing manager. Disputed evidence was completely ignored. The disciplinary hearing was a kangaroo court. The trust member of the executive team, whose role was to oversee fairness for both sides in the hearing, sat next to the KC and spoke regularly to him throughout the 3 days, which should not have happened. She should have simply been overseeing fairness, not advising the trust. The outcome letter had clearly been written in part before the disciplinary hearing because it contains facts which were agreed in the disciplinary hearing as being incorrect, but still appeared in the letter as being correct. The hearing manager stated that he preferred the evidence given by the trust witnesses, even though we had clearly shown that the witness had misremembered the events. Conclusion: summary dismissal for gross misconduct. We appealed the decision. The date of the appeal hearing was set over 2 months from the date of dismissal. The panel was made up of 3 decision makers: a non-executive director, the chief nursing officer, and the director of communications and marketing. The minutes of the disciplinary hearing were emailed to me and my trade union official at 16:46, the day before the appeal hearing. They were 90 pages long. Given that the hearing manager should have relied upon these minutes to write the outcome letter, it does raise the question as to what he relied upon when he wrote the letter. Or maybe he didn't write it at all. At the disciplinary hearing, one of the HCSA's relatively new national officers attended as an observer and took her own notes. These notes, although not a complete record of the hearing, allowed us to make a comparison with the trust minutes. The minutes were clearly inaccurate and had been altered significantly in the trust's favour. Words and phrases had been removed, other phrases were embellished, whole paragraphs were inserted. The KC had been particularly aggressive and rude in his questioning of me, and any evidence of that had been removed from the minutes. Despite the limited time available to review the minutes, we identified some major differences between the two versions. My trade union official brought this up at the appeal, but the KC stated that he had read the minutes and was happy with them, which begs the question whether he read them at all or was complicit in their editing. The appeal panel were also happy with the minutes, and the appeal hearing went ahead. The appeal panel upheld the decision of the hearing manager. My case was judged as having a reasonable chance of success at an employment tribunal, so we went ahead with it. It is really important to understand that an employment tribunal for unfair dismissal is a test of whether the process of dismissal was fair, not whether the dismissed actually did anything wrong. Therefore, it is possible to win an ET even when the claimant was actually guilty of misconduct, if the process of the dismissal was flawed, and of course, vice versa. Probably the best place to go after an unfair dismissal in this situation is the High Court for a judicial review of the decision. But this is for another time. And the main barrier of going to the High Court is cost. And depending on the response we get from this webinar, we could do a part 2 about an employment tribunal and High Court. For now, I will hand over to Martin.
Sasha. Well, my name is Martin Bond. I'm National Officer for the HCSA in the Northwest of England. I'm the National Officer Lead on Whistleblowing for the Union. I cover trusts from Carlisle down to Crewe and from Chester across the Tameside. The trusts across Greater Manchester, the Liverpool City region, Cheshire, Lancashire and Cumbria occur for a population in excess of 7 million. So outside of London and the South East, this is the most populous area of the country. But I want to talk about taking action before those really significant and horrible things occur that Sasha just talked about. And again, I won't talk about what happens after whistleblowing has taken place and detriment has then occurred, because that could be a whole webinar of itself. I carry a caseload with a significant proportion of whistleblowing matters, as do my national officer colleagues in their geographical areas. And when I was preparing for the webinar, I had mixed feelings, really. I was enthused about being able to assist Sasha in empowering members and non-members to identify risks to their career, short-term and long-term, through whistleblowing, but also disappointed that we actually need to undertake this exercise at all, bearing in mind that the protective legislation is from 1998. I want to talk about the practical elements of blowing the whistle from the side of the medics. I'll refer to whistleblowing as protective disclosures throughout. It's the same thing. So the first slide, Gabriel, please, if you could have that up. So this indicates some important elements of the legislation. It's from the government guidance on the gov.uk website, and links will be provided to this and several other resources through the webinar. Now, it's worth mentioning here that I am not a lawyer, and neither are my colleagues. We use the legislation in individual and collective workplace issues, not in tribunals. So essentially, I want to give you some of the tools that should allow you to identify where you may be making a protective disclosure, how to make such a disclosure to trigger the legal protections, and therefore try to mitigate the risks of doing so. It is much better to take control of a whistleblowing situation as far as is possible, and where the legislation allows. It's better to do that than to end up in a situation that Sasha has ended up in. There's a generality that, as a trade union official, that I encounter across my work, and every trade union official does, no matter where they work. We are very often presented with a set of facts, worries, concerns, and questions about what may flow from a work situation and what may happen in the future. And inevitably, the member then asks, can they do this? The simple answer to that is always the same. They can do whatever they want. Whether it's lawful or not is a different question. There's always a supplementary answer to that question, which is if no action is taken, then they can do whatever they want and will succeed. It is always a question for the member about whether they want to take action or not. In whistleblowing, for most doctors, there's definitely a difference in the answer to that question, but whether you're going to take action or not, depending on where you're up to in your career. Seniority certainly plays a role in my experience. The further you are into your career as a doctor, the more you are prepared to challenge your employer. So firstly, I want us to consider what whistleblowing actually is, generally. Government guidance states that within a workplace, whistleblowing legislation will be engaged if there's a report by a worker of certain types of wrongdoing. There has to be a public interest in the disclosure. I'm sure everybody here would agree that negligence or recklessly risking patient safety is clearly something in the public interest. There's no time bar to when a whistleblower can raise concerns, but obviously the older the material issue or index incident, the more difficult it can be to investigate properly. It's important also at this stage just to note that self-employed doctors working in the NHS are covered by the legislation as workers under the Act. Further guidance on the government website clearly states that reporting a danger to someone's health and safety is a protected disclosure. It also states that a report of covering up wrongdoing constitutes whistleblowing. As I stated, I'm not a lawyer, and what would constitute covering up as defined in case law is not something I can go into. But certainly, the guidance provides a trade union official with tools to help members at an early stage in a workplace. Just dealing with that second element for a second, and it is the zeitgeist, isn't it? Because it's already been reported that the Letbury inquiry is hearing of complaints that reputation management by managers was placed as a priority at the expense of consultants who reported safety concerns. And it's certainly something that I see on a regular basis in my casework. Not every trust where I'm involved in whistleblowing, however, is like that. But there are certainly one or two repeat offenders who engage the management playbook. Those trusts simply don't learn from the lessons of the past in their management culture. So having established that raising patient safety concerns can be a qualifying protected disclosure, I want to touch on the process that must be followed to ensure the legislation covers the worker before moving on to the actual protections and how to ensure there is no doubt that those protections are engaged. That said, where an employer is committed to a course of action that may well be unlawful and brings serious damage to the career of a doctor, it's not unknown for the employer to bat on regardless and force the whistleblower to go to law. As Sasha said, that's a separate issue. That's a separate webinar all of itself. So there are many testimonies out there, and Sasha touched on a few of them, that show that the whole issue of whistleblowing can be a grueling process. Preventing the matter from becoming protracted and avoiding an MHPS process on the back of the disclosure is ideal. However, as Sasha has spoken about, there is an absolute regulatory duty to the safety of patients. Next slide, please. The applicable legislation is the Public Interest Disclosure Act 1998, brought in the early days of the last Labour government. The focus of this webinar is on patient safety and the overarching duty of doctors in that regard, so I won't go over the wider elements of the Act. There are other situations, aside from the danger of harm and covering up, which may apply to individual situations, but almost all of the work I see flows from the first two issues, and in many cases covers those two issues entirely. So in addition to the qualifying criteria, the disclosure must be made in good faith, be of a reasonable belief, and not manifest in the commission of an offence. Section 43C of the Act asserts the coverage to an employer where the employee has made a disclosure directly to them. And many of the cases that we see, it isn't always the case that we advise a doctor to engage that section of the Act, particularly where there is a significant lack of trust in the organisation and or it's deemed tactically to be more advantageous to notify one of the other prescribed organisations that you can make a protected disclosure to. Now, we'll put a link into where the whole list of organisations is detailed by the government. But just for our purposes here, a protected disclosure can be made to a legal advisor in the course of obtaining legal advice, but not a trade union, significantly. A Minister of the Crown, a Member of Parliament, the Health and Safety Executive, the GMC and other regulators, a local authority, or the CQC. Now, the list is extensive. As I say, a link will be provided. I would urge any members with concerns about making a protected disclosure to seek advice from the HCSA to ensure that the disclosure is submitted in accordance with the legislation. Next slide, please. So once a qualifying protected disclosure has been submitted, legend provides protections at Section 2. The worker has the right not to be subjected to any detriment by any act or any deliberate failure to act by his employer done on the ground that the worker has made a protected disclosure. This is the element that gives further protection to whistleblowers. Now, Sasha Taylor is one that is really significant in terms of the impact on her and her career. But it's sanitary lesson for every doctor now. I'm not going to go over the kind of issues that happen with Sasha, but these are some of the things that I can see for whistleblowers. So detriments can include MHPS investigations for trivial matters, conduct disciplinaries for trivial matters, rota disruption, appraisal disruption, revalidation disruption, leave request disruption, job planning disruption, attack on private practice, and the use of GATIC incident and risk reporting as a weapon. And that's not an exhaustive list, but it gives a flavour of the things that can happen, and they would cause detriments. So making the employer aware that the legislation has been engaged should create an element of jeopardy and dissuade them from engaging the management playbook. As I've already said, this doesn't necessarily mean that they desist from going down conduct or capability routes, or even mess you around on revalidation, which is really quite nasty. If they're out to get you, they will be out to get you. There are other ways of raising the stakes in addition to making it explicit and showing your employer that you are a whistleblower. Every trust should have its own whistleblowing policy with various discrete stages. In my experience, it's mainly just for show, unfortunately. Many policies identify a non-executive director as the person with overall responsibility for whistleblowing at the trust. Now, it's not unknown for the identity of this non-executive director to be completely opaque. I have experience of a member making a protected disclosure who had no trust in the organisation and using the policy to go straight to the non-executive director, which was a qualifying part of the policy. But it was impossible to find out, either from inside the organisation or publicly, which one of the dozen or so non-execs was responsible for whistleblowing. So as a matter of belt and braces, I notified every single non-executive director of the nature of the protected disclosure and the fact the legislation had been engaged because I had to. And I apologised to them all for doing so. Now, I got some reasonably encouraging responses from some of them, but not from the responsible non-executive director, who wasn't particularly impressed, to say the least, with what we'd done. But that exposed a real shortcoming in the operation of the policy and caused embarrassment. That exposure to all the non-exec directors, I think, wasn't harmful to the case. In many ways, raising the stakes for the employer is a tool for protecting and advancing our members' interests individually and collectively. It's really disappointing that we are forced to use leverage to protect our members who only want to comply with their overarching duty as a doctor and protect their patients. In our work, your national officers regularly deal with matters where an array of policies are used to deflect and defray from member issues. For example, you brought your issue as a grievance, but you should have brought it under the dignity at work policy, and therefore you'd have to start again. That's a common one. That's designed to delay and to time out the complaint. Policies do cut both ways, however. And when considering whether or not to make a protected disclosure and be ready for any potential backlash, your national officers can bring policies to the table in addition to the protections of the legislation which I'll set out. Now, I appreciate it's all well and good having an understanding of where raising patient safety issues sits in legislative and employment rights terms. In your personal realities, protected disclosures will usually involve actions or omissions of colleagues, a failure to implement up-to-date safe practice, failures of policies and procedures. Very often, this will mean that colleagues and direct line managers come within the arc of the disclosure. That's why it's critical to get early assistance from the HCSA when you find yourself in a position where you feel compelled to raise a safety issue or are worried about the impacts on your employment. We can engage the protections of the law and policy to bring to bear as a protected disclosure is submitted. It's not a silver bullet in every situation, but in the absence of doing so, the individual is more vulnerable to the employer's playbook. As a final point, I just want to briefly talk about some of the campaigning HCSA is undertaking and the potential for the new Labour government to empower whistleblowers in the NHS. Sasha and I will be attending Labour Party conference next week and with the playbook. We will be engaging policymakers and allies to lobby them to bring about jeopardy for managers who engage the management playbook against all medical staff who report safety issues. Wes Streeton, Don't All Boo, has said, according to the BBC, that they're going to take steps to make sure that senior managers are regulated so that if whistleblowers are silenced by managers, those managers do not work in the NHS anymore. That's what I mean by jeopardy. Sasha is also working with various interested organisations, including Justice for Doctors, Whistleblower UK. We also continue to use the union's strength as a TUC affiliate to lobby government and are hopeful that this government is more concerned about the NHS and its staff than the previous one. At TUC Congress last week, the HCSA motion on whistleblowing was adopted as TUC policy. Again, Gabriel can provide a link to that to you later. Anyway, you've been subjected to my voice and my cough for too long, but I hope I provided some insights on what we can do for individuals and groups to mitigate the brutal consequences of management using the playbook against doctors. After all, you're just trying to do your job. As a final line for anyone in an active position of authority in the NHS who may be on this, I hope you at the least take away from this webinar the fact that we won't let our members be sacrificed and harmed simply for doing their jobs as doctors. Indeed, I hope you'll be able to recognise poor practice in your own workplace and call it out yourselves. Thank you very much.